be moving on to hear the evidence of Ms Parks for the Council. Could everyone silence phones and other devices? In terms of today, we must be finished by 4 o'clock at the latest, and we need to clear this room. We're making reasonable progress on our timetable, and we're sort of minded at the minute to finish today with Ms Parks' evidence, whenever that is, and then adjourn for the weekend, unless we finish at 10:30 or something like that, at which time we will need to reconsider that. Mr McIntosh, did you want to say something about Mr Leventhal's recognition?
Yes, thank you. The one I produced rather recklessly had no page numbers or paragraph numbers. I produced one with numbers, which I showed to those acting for the appellants. I understand their content that I haven't secretly added extra words. So I'm proposing to, during the day, to send a copy electronically to everybody and bring hard copies on Monday morning. I don't think it's going to arise today unless I've misunderstood where we're going. Thank you.
Perfect. That sounds fine. Anything else from anyone else?
So I have just one matter, just on progress. I had understood that we'd agreed that Historic Scotland would not start today. I don't know if that's the point my learned friend was going to make, and I had, perhaps he's going to speak for me, so to speak, but I've prepared on the basis that Historic Scotland do not start till Monday, so I would be in some difficulties if that was not the case. I understood the relevant witness was away on holiday, or there were other practical difficulties, but it may be that will be confirmed.
That sounds fine. Mr Mackay.
Yes, that is also my understanding, sir, but I did have an additional matter I wanted to raise before we start the evidence this morning, and that arises an increasing concern on the part of those instructing me over the possible implications arising out of the proposition put by Mr Steele to the Council's witnesses over the last couple of days that there was no prospect, as he put it to Mr Leslie, and not the remotest possibility, as he put to Mr McMeekin, of the music school proposals proceeding due to a legally binding contract between the Council and the appellants. And yesterday Mr Steele took that a step further by suggesting to Mr Leslie that as a consequence under paragraph 347C of HESPs, the music school proposal became irrelevant as it was not an option that would ensure a continuing beneficial use. There are two major concerns that I hold, sir. The first is whether this line is supported by the appellant's case, and in particular the expert planning evidence of Mr Mappin. I've looked again at Mr Mappin's inquiry report, and I can't see any supporting argument. The relevant paragraphs seem to be, for your notes, sir, paragraph 2.35 and 328 of his inquiry report. And also paragraph 2.7 of his precognition, where the music school proposal is referred to, but no argument to that effect is advanced. In the planning statement, which is CD 186, at paragraphs 4.5 and 4.6, Mr Mappin does refer to the fact that the Trust would be aware that there was a long-term contractual arrangement. But he then goes on to invite comparisons between that scheme and his client's scheme, effectively in a review under the terms of clause 3.47C. So in other words, the point that's been put to the Council's witnesses is not part of Mr Mappin's evidence. And because it's not part of Mr Mappin's evidence, obviously he wasn't cross-examined on the issue. The second aspect, which is perhaps a greater concern in my submission, is whether there is a clear factual basis before the inquiry which might be capable of supporting Mr Steele's line of argument. In that respect, all parties to the inquiry have a fundamental difficulty in that the legal agreements are heavily redacted and therefore the relevant provisions are not available to the inquiry. There are three documents which bear upon this issue, sir, and if I can just briefly take you to each of those. The first is CD 161.
You need us to look at those?
If you could briefly look at those documents, sir, I think it might be helpful to understand where we've got to in evidence. CD 161, which is the position statement of January 2017. And if you look, please, to electronic page 7, also hard copy page 7. At paragraph 11.1, which is the paragraph that Mr. Steele put to Mr. Leslie, it said that in December 2015, the Trust applied for permission for an alternative scheme. This application was approved by the Council's subcommittee. However, the Royal High School Preservation Trust does not have an agreement with the Council relating to the use of the Royal High School, and the Council remains under contract with DHP, so there is no prospect of these proposals going forward at the time being, as in at January 2017. If you look up to paragraph 7.2 on page 5, there is some information about the nature of the contract. And it says the Council subsequently entered into negotiations with DHP on a contract for the disposal of a leasehold interest in the property to enable DHP to develop the property in accordance with its proposals. In 2014, the Council entered into a conditional contract to grant DHP a 125-year lease of the property on a full repairing and insuring basis at a peppercorn rent, with DHP paying a grassam for the benefit of the lease. The contract is conditional on DHP obtaining planning and listed building consent for the development and a satisfactory building asbestos site investigation services report for the building. That being the case, sir, we turn next to CD 186, to the Pinson's letter. That's CD 186. And if you go, please, to Appendix A.1, which is electronic page 46. You will recall this document was featured in evidence previously, and in the last two lines, Pinson's, the partner for Pinsent Masons LLP, confirms that the ultimate long-stop date for purification of the suspensive conditions in the missives is 31st March 2021, subject to permitted extensions in accordance with the terms of the missives. And because we don't have the relevant agreement, we simply don't know what that amounts to, if anything. Clearly, the intended long-stop date is the end of March 21. The third document that's worth referring to, which postdates these documents, is the planning report, i.e. the report to the subcommittee, that's CD 425. You perhaps don't need to turn to this document, sir, but the point is simply that that document at pages 21 to 23 discusses HESP's paragraph 3.47c, and it's clear from that discussion that the author of the report, which was signed off by Mr. Leslie, as I understand it, treated the music school as an alternative proposal for the purposes of that test, or consideration, as Mr. McMeekin explained yesterday. So, in short, sirs, it appears to those instructing me that there's a lack of clarity on what is potentially an important point, i.e. whether the appellants hold exclusive rights to control the site after the long-stop date of March 21. And in my submission, that is to the potential prejudice of all parties to the inquiry, and would indeed be deeply regrettable insofar as your own position is concerned if submissions were to come to be made on the relevant paragraph of HESPs without there being a clear factual background. So, sirs, what I would respectfully invite you to do is two things. First of all, to ask Mr. Steele to confirm definitively whether it is part of his client's case and whether he will submit that for the purposes of paragraph 3.47c of HESPs, the music school is not an option, even after the long-stop date, as a consequence of the legal agreement.
you're not raising any issues in regard to prior to the long stop date. It's what might happen afterwards.
And it seems to me, sir, that if the long stop date is what it appears to be, then parties are able to make submissions already on the basis of what HESPS is intended to achieve. And bearing in mind the time it will take for you, sirs, to write up your reports, the report to go to ministers, and for ministers to actually make a decision, March 21 will not be that far away. It may be a year or two, perhaps.
I'm going to share it.
I wasn't meaning your inputs personally, Mr. Ron. So it seems to me that that is one matter. The more worrying aspect is, of course, if it's being asserted, as it most certainly was in the questions that were put to the Council's witnesses yesterday, that there was no prospect at all of the trust scheme being delivered or implemented. And if that is Mr. Steele's client's position, and if he does intend to submit, make submissions to that effect, then in those circumstances I would invite you, sirs, to further request confirmation of the factual position from the Council and the appellants, which they could do either by way of a joint statement or through disclosure of the relevant contractual terms. And I emphasise the relevant contractual terms. There's no fishing exercise here. There's no intention to delve into commercial matters. It's simply those which bear upon this issue.
Thanks, Mr. Mackay. Mr. Steele.
Good morning, sir. So I pause to note that I'm astonished that Historic Environment Scotland haven't been researching these matters about a year ago before they made the appropriate consultation response in relation to our latest scheme. Because what I do refer to and do rely upon is the HESPS tests. Without question, they are a material consideration to which considerable weight should be given in the current circumstances. And, sir, you, I suggest respectfully, will be obliged to consider them, as will the ministers in due course. So it can be no surprise to Historic Scotland, whose guidelines these are, that we are referring to them. The terms of the HESPS tests are absolutely clear. And so far as the relevant paragraph is concerned, the first test, as Mr McMeekin very fairly accepted yesterday, is whether the options would ensure, which in the normal use of the English language means we would have to be certain that they would have a continuing beneficial use. So we have to be certain about the Trust's proposals being able to deliver, put short. There's nothing new about this, sir. Our statement of case, or was it planning statement, is actually at paragraph 4.5, sir, not 4.6 as was stated. It quite clearly states that we have a long-term contractual arrangement with CEC on the high school. There's no surprise about that. And indeed, we have lodged a letter from Pinsent Mason, which my learned friend has referred to, stating exactly that. And perhaps if I can draw attention to the precise terms of that letter, what it actually says is, in the last two lines, the ultimate long-stop date for purification of the suspensive conditions in the missives is 31st of March 2021, subject to permitted extensions in accordance with the terms of the missives. It makes it perfectly clear that the 31st of March 2021 is not the end of the matter because there are permitted extensions. And that document was lodged as part of the planning statement, as I understand it, and as part of the appeal papers. So there's no surprise in any of this at all, sir, that A, we are referring to the HESPS test, B, we regard it as a material consideration, and I most assuredly do rely on it, and I rely on the evidence which is before you. It is for those reasons that I cross-examined Mr Leslie and got very fair answers from him, and Mr McMeekin in similar vein. And you have the questions and you have the answers. And the position is this, sir, that I will most certainly be submitting that in terms of the HESPS test at the relevant paragraph, one cannot ensure a continuing beneficial use at the hands of the Preservation Trust, quite simply because they have got no legal interest in the site. We do. Now, I know that attempts were made previously, I think yesterday, to try and save this submission being made with a view to saving time this morning, sir, because there's already an offer of a joint statement to be made between the Council and ourselves, which would seem, with respect, to address any such issue. And I know that that matter is in hand, and I'm therefore struggling to understand why this matter should have been raised this morning.
Can I respond very briefly, sir?
Mr. McKenna.
Yes, thank you, sir. So Mr Steele has been helpful to an extent in confirming what he intends to submit, scrupulously avoiding confirmation of the point that I carefully framed for consideration. Secondly, the issue was raised because I haven't had it confirmed to me that there's to be a joint statement. That's news to me.
Is there anything you can help us with, Mr. Thompson, on this matter?
I rather doubt it. Everything that's been said is correct. I've spoken to my learned friend Mr. Steele and Mr. Mackay. There are ongoing discussions between myself and Mr. Steele about the preparation of an agreed statement. That had seemed to us, without full instructions on the matter, probably to be the most straightforward way of proceeding. I'm awaiting formal instructions. We've been discussing, for example, who should prepare the first draft. So matters are in hand. It's regrettable that the information shouldn't be available in definitive form, I suppose, before HCS's witnesses give their evidence on Monday. But I wouldn't have thought that that was an insuperable problem because they could give their evidence on an either-or basis. So I would hope that the progress of the inquiry won't be hindered by this, and I will certainly endeavour to ensure that the Council cooperates in producing the agreed statement as soon as possible.
Thanks, Mr. Thompson. That was helpful, in fact. Can you bear with us just for a second?
So can I just make one observation?
Mr. McIntosh.
I don't want to go back into the details of anything that was discussed 2 days ago, but it does strike me that the question of identity that was discussed 2 days ago, the identity of the vehicle and the identity of the appellants, that is raised in CD 585, which is the further submissions to Scottish ministers lodged by me in November 2017, from paragraphs 39 to 45, could well be addressed by careful drafting in such a statement, because in essence a statement of whether they have a long stop rather presupposes a clarity about who they are. And so I would ask that that matter could happily be rolled into that process and therefore avoid any other need to do anything else. Thank you.
Thanks, Mr. McIntosh. Yep, that's maybe something that you want to consider for the joint statement.
So we'll consider anything within reason, but actually the answer to it is surely already contained within the Pinsent Mason letter dated the 9th of February 2017. But we'll consider the point that is raised.
Okay, thanks for that. Okay, we'll be very grateful if the appellants and the council can produce that joint statement. We don't think that this should derail or delay the inquiry, and obviously you will deal with that as you think fit during your leading of HES's evidence. But the sooner the joint statement is produced, the better, I would have thought.
Yes, sir. It may be that I have to formally reserve my client's position if there isn't clarity before Mr Robb gives evidence.
That's fine.
Thank you.
Anything else? No. Okay, Mr Thompson.
Thank you, sir. Good morning, Mrs Parks, after that short delay. I think your evidence to the inquiry is to be found in three places. Your principal precognition, your rebuttal precognition, and your inquiry report, which is, I think, CEC 6. And I hope you've got all of those in front of you.
Yes.
Could I, and I think that consideration has been given to the ways in which we might reduce the precognition. Unfortunately, the only easy way to do that is to omit the Session 2 part, which we would be omitting anyway. Mrs Parks' precognition covers a lot of ground fairly briefly. She didn't take advantage of the opportunity to have two separate precognitions, so the part relevant to this part is actually shorter than you might think. So, subject to that introduction, could I ask you, please, Mrs Parks, to start reading at 1.1 of your precognition?
Thank you. I am Carla Parks. I am a Senior Planning Officer with the City of Edinburgh Council, and I was a case officer for both the 2015 and 17 planning applications subject to this inquiry. My professional experience and evidence is detailed in my inquiry report. The scope of my evidence will cover my assessment of the 2015 and 17 planning applications against the relevant policies of the development plan and other material considerations in terms of the Town and Country Planning Scotland Act 1997. It will address the impacts of the 2015 and 17 proposals on the designated heritage assets, and secondly, the architectural design quality of the 2015 and 17 proposals. To begin with, impacts on listed buildings and their setting, the impacts of the proposed demolition, a detailed evaluation of the impacts of demolition on the Category A listed buildings on site is included in the listed building reports of handling on both applications and explained in Ewan McMeekin's inquiry report, which examines compliance with the Planning, Listed Buildings and Conservation Areas Scotland Act 1997, hereafter called the LBCA, and the relevant provisions of Historic Environment Scotland Policy Statement. Ewan McMeekin's conclusion is that the provisions in Historic Environment Scotland Policy Statement regarding demolition are not met in this case. His conclusions are consistent with those of HES itself. I consider these findings to be highly relevant to the assessment of the planning applications. Edinburgh Local Development Plan Policy ENV2 is a development plan policy dealing specifically with demolition of listed buildings. It reinforces the provisions in HES PS regarding demolition and states that demolition will only be allowed in exceptional circumstances. As explained in my inquiry report, the case for the demolition of the listed luncheon hall and classroom block is accepted on the basis that they are of no significant special interest in their own right. However, the case for the demolition of the listed gymnasium building and lodge building is not accepted. The proposals are considered contrary to LDB policy ENV2, in particular the public benefits, including the economic benefits, do not outweigh the loss. Moreover, given the significant impacts on listed buildings arising from their demolition, there is a strong presumption against the grant of planning permission in terms of Section 59 of the Planning, Listed Buildings and Conservation Areas Act. Impacts on character and setting of the Hamilton building. The 2015 and 17 application proposals would have significant adverse impacts on the character and setting of the Hamilton building, largely as a result of the significant height and scale and positioning of the proposed extensions, which are not subordinate in height or scale or excessive in appearance in relation to the Hamilton building. The resulting detachment of the building from its landscape setting, including the listed monuments on the hill, is another impact. These detrimental impacts are explained in Ewan McMeekin's inquiry report and demonstrated in the findings of the Townscape and Visual Impact Assessment for each application, which are referred to in Julie Waldron's and my inquiry reports. Such adverse impacts upon the Category A listed building demonstrate that the proposals would firstly fail to safeguard its character and special interest, fail to respect its sensitive setting, and be severely detrimental to its appearance at this prominent landmark location. The proposals are therefore contrary to LDP policies ENV 3, listed buildings setting, and ENV 4, listed buildings, alterations and extensions, as referred to in the reasons for refusal of both planning applications. Accordingly, a strong presumption against granting planning permission also arises under Section 59 of the LBCA. Impacts on other listed buildings. The setting of the Category A listed National Monument and Nelson Monument are adversely affected under both the 2015 planning application proposals, as referred to in my inquiry report. Impacts on the National Monument would harm the visual connection and understanding of the relationship between the Hamilton building and its picturesque landscape setting, including its visual and cultural connections with Athens. As is evident from viewpoints 22 Market Street, the 2015 and 17 proposals would damage the setting of St Andrew's House by reducing its landscape setting and diminishing its presence on the hill. These adverse impacts further demonstrate that the proposals fail to comply with LDP policy ENV 3, as explained in my report. Accordingly, a strong presumption against planning permission also arises under Section 59 of the LBCA. As explained in my inquiry report, the damaging impacts found as a result of the height, scale, massing and positioning demonstrate that the proposals fail to meet the provisions of LDP policy DES 11, which is relating to tall buildings, skyline and views. Contrary to Hannah Tweedy's criticisms as to inconsistency, these adverse impacts were identified in paragraph 3.3 of both reports of handling. Impacts on conservation areas. Calton Hill is noted in the Newtown Conservation Area Character Appraisal as the most prominent natural landmark within the area. In both appeal proposals, it is found that the character and appearance of the Newtown Conservation Area are adversely affected because the views to the prominent landmark feature and appreciation of its topography are damaged where the proposed extensions impact on important views of this landmark and its distinctive profile. The setting of the iconic Hamilton building and other listed building monuments and buildings on this hill would be damaged, as would their cultural relationship, which are a key part of the area's character and identity. The adverse impacts found on the setting of the landmark Hamilton building and monuments on the hill would detract from the carefully planned landscape within the Newtown Gardens and its unique composition. The character of the Old Town Conservation Area would also be adversely affected, owing to the damage caused to notable views towards a prominent landmark site in the New Town from the Old Town, as explained in viewpoints 19A and C in the 2015 application and 19B and C in the 17 application, and that is Canongate Church Burial Grounds. The significant adverse impacts found above demonstrate that the proposals fail to preserve or enhance the character or appearance of the New Town Conservation Area and the character of the Old Town Conservation Area. Excuse me. I therefore maintain that the 2015 and 17 proposals are contrary to LDP policy ENV 6 relating to conservation areas and development. Sorry. Accordingly, there is a strong presumption against the granting of planning permission under Section 64 of the LBCA. Impacts on Calton Hill. Calton Hill is subject to a number of statutory designations. The impacts of the proposals are set out in my inquiry report. As found in my inquiry report, the proposals subject to both applications would have significant adverse effects on the appreciation of the Calton Hill Special Landscape Area, SLA, landform and its landscape character. The proposed large-scale extensions, particularly the West Wing, will reduce the proportion of the undeveloped skyline visible in views of Calton Hill. In doing this, they will adversely affect appreciation of its natural profile, and that's more in the case of the 2015 proposals. This is evidenced in viewpoints 21, 22 and 19, which are Regent Road, Market Street and Canongate Church burial grounds. The proposals will adversely affect the appreciation of the landscape character of the hill, as they would add substantially to the skirt of built form on the platform on the southern side of Calton Hill and reduce the visible proportion of natural landscape. The proposals would adversely impact, and more so in the case of the 2015 proposals, on the appreciation of views of related topographical features of Salisbury Crags and Arthur Seat from Waterloo Place, which is illustrated in viewpoints 4A to D and alluded to by SNH, Scottish Natural Heritage, in their consultation response to both applications. The proposals are considered contrary to LDP policy ENV 11, which is relating to special landscape areas, as the proposals fail to safeguard the essential qualities and characteristics of this SLA. The impacts on Newtown Gardens inventory site. The site and hill lie at a highly prominent and sensitive location in the Newtown Gardens inventory site. The monuments in this part of the inventory site and the Hamilton building contribute to the composition within this unique, picturesque landscape. The 2015 and 17 proposals would damage the composition of the hill by altering its key characteristics, including the space around the monuments and the semi-rural character, as well as creating new focal points. The proposed means of mitigation through the design of the building and public realm do not mitigate the significant adverse impacts on this designation. The proposals fail to comply with HAS's managing change guidance on development within this inventory designated sites. It is therefore maintained that the proposals are contrary to LDP ENV 7 relating to design gardens and landscapes. Impacts on World Heritage sites. The Hamilton building is the most important Greek revival building in the old and new towns of Edinburgh World Heritage Site. The proposals, if implemented, would seriously threaten the fusion of buildings and landscape that make up Calton Hill and in turn impact adversely on the key spatial attributes of OUV, that is outstanding universal value, and thus on the OUV of the Edinburgh Old and New Towns World Heritage Site, as referred to in the objections from ICMOS on both applications. I agree with this viewpoint. Furthermore, the proposals would damage the cultural value of the building and its landscape setting on Calton Hill that reflects its link to the Enlightenment thinking and strongly contributes to the OUV. It is therefore contended that the proposals are contrary to LDP policy ENV 1, as they fail to safeguard the OUV of the old and new towns of Edinburgh World Heritage Site. The methodology used in the Heritage Impact Assessment for each application and the effects found on OUV are not all agreed with, for the reasons stated in my inquiry report. I would also refer to HES and Edinburgh World Heritage Trust submissions on both applications, which have been are available with the records for these applications. Architectural design quality. The proposal is within the relatively constricted yet visually prominent curtilage of the Category A listed Old Royal High School. This building represents the finest example of Greek Revival architecture in Scotland, and is referred to in HES's listed building description, statutory list. The site also constitutes a visually prominent and sensitive part of the Newtown Gardens inventory designed landscape and World Heritage Site. The proposals have the potential to impact on both the character and visual qualities of the natural and designed landscape of this SLA and GDL. Height and scale and form of development and its relationship with its context are fundamental considerations in assessing the appropriateness of any design scheme, and as recognised through the provisions of LDB policy DES 4 development design setting. The two extensions proposed under the 2015 application are up to 10 metres higher on the west side and 4 metres on the east than the pediment of the Hamilton building, and of significant length and volume. They are also significantly higher than other buildings on this part of the hill. The overall scale of the development in the 2017 proposals is reduced. The west extension is approximately 5 metres lower than previously, achieved through the loss of a storey level and a reduction in the height of other storeys. The east wing, while differently orientated and articulated from the 2015 proposals, remains similar in height. Both extensions remain significantly higher than the pediment of the Hamilton building and greater in volume and footprint. A number of other measures have been incorporated in the design solution for both the 2015 and 17 proposals in an attempt to mitigate the impact of placing such large-scale development next to the listed building at this highly sensitive and prominent location. The intentions of this sophisticated architectural response in this design are acknowledged. However, I maintain that the measures employed are insufficient to overcome the many damaging impacts found in locating such large-scale extensions within this highly prominent and sensitive setting. The varying impact resulting from the use of a high proportion of glazing and the effects of different lighting conditions are referred to in Julie Waldron's and my inquiry reports. The adverse impacts of the proposals mean that, whilst the proposed buildings in themselves may be considered a sophisticated architectural response, their sheer scale and massing mean that they are contrary to LDP policies DES 1 and DES 4. Too much development is proposed within this relatively confined and highly sensitive site, in my opinion. The negative impacts found as a result of both the 2015 and 17 proposals on the city skyline and important views of landmark buildings and features and the city's landscape setting also demonstrate that the proposals are inappropriate for the sensitive location and contrary to the provisions of LDP policy DES 11, which relates to skyline and views. In terms of land use policy context, the economic and employment policies of the LDP aim to assist in delivering economic development at accessible places, including the city centre, in interpreting the relevant provisions of Scottish Planning Policy, the SPP, and National Planning Policy Framework.
So, sorry, Ms Parks, is this not that part of the precognition for inquiry session 2, Mr Thompson?
Well, with respect to that, sir, no. This is the policy context into which the economic impact will slip in due course.
Okay.
I was not proposing that Mrs Parks should read from 9.6 onwards, but these next 3 or 4 paragraphs, as they deal with the policy context,
the context.
It's
Okay.
perhaps appropriate to have that here.
That's fine. Apologies.
Thank you. The National Policy, National Planning Framework, which is NPF 3 at local level. The LDP recognises the importance of the tourism sector to the economy. The provision of a proposed hotel at the central location complies with the general provisions of LDP policy EMP 10, hotel developments. The proposals comply in part with LDP policy DEL 2, relating to the city centre, and the Princess Street Block 10 development brief, as I say, in part, as explained in my inquiry report. However, as set out in my inquiry report, I consider that both the 2015 and 17 proposals do not accord with the development plan overall, as they breach a significant number of LDP policies. The proposed hotel accords with NPF requirements in terms of its central location, which is identified as a focus for growth and investment and tourism and a commercial hub. However, NPF 3 also recognises that Edinburgh's world-renowned built heritage is a key asset. I maintain that the appeal proposals would have many damaging impacts on the built heritage, as evidenced in my inquiry report, including significant adverse impact on its World Heritage Site setting, which NPF3 recognises as a key asset. I therefore conclude that the proposals fail to accord with these important requirements. Scottish Planning Policy Statement sits along NPF3, which provides a statutory framework for Scotland's long-term spatial development. The principles of the SPP include a presumption in favour of development contributing to economically, environmentally and socially sustainable places. The proposed reuse of this existing building for a tourism-related use at this accessible city centre location responds to SPP principles supporting economic growth. However, I maintain that the many damaging impacts and irreversible impacts found as a result of the proposals on the city's cultural and historic heritage demonstrate that the proposals would fail to meet the SPP requirements, as evidenced in my inquiry report. The 2015 and 17 proposals are not considered to be consistent with the SPP objective to deliver the right development in the right place.
And I think if we could move on to 9.13, please.
Yes, thank you. As stated in the Council's report of handling, the city's historic and cultural heritage and landscape setting are recognised as key attributes which attract tourists to our city. I maintain that the proposed development would result in significant long-term damage to the city's cultural and historic heritage and landscape quality, potentially impacting on its status as a World Heritage Site and reducing its attractiveness to tourists. There is a risk that such adverse impacts could result in long-term harmful consequences for the city's tourist economy. I therefore maintain that the potential economic impacts arising from the operation of the proposed hotels in both the 2015 and 17 proposals would be outweighed by the resulting serious long-term damage to the city's built and natural heritage assets, and potentially impact on the attractiveness and success of the city as a tourist destination. And finally, in respect of the Royal High School Preservation Trust proposals, Gary Mappin's inquiry report considers the Royal High School Preservation Trust proposals as the alternative scheme. The Council as Planning Authority considered the RHSPT proposals on their own merits and not as an alternative to the appeal proposals. In response to the comment in paragraph 2.74 of Gary Mappin's report about the RHSPT's objective, the Council received and determined the application in good faith.
And I don't think we need read your conclusions, which largely repeat what you've already said. There are two other matters, Mrs. Parks. One is that in your evidence you make reference to planning conditions, and in particular in your report, paragraph 13.17, you give us certain evidence about your view on conditions there. Are you content that the whole matter of conditions should be put off to the hearing session on that subject?
Yes. Sorry, what paragraph is that again, please?
13.17.
Yes, I'm satisfied that that would be the case. Thank you.
And finally, I'm not going to ask you, you'll be pleased to hear, to read your rebuttals, but could I ask you just to look at the first page of your rebuttals, because I think there's a correction that you would like to make to paragraph 2.1.
Yes, thank you. I would like to clarify that where we talk about the music school applications being dealt with consistently in terms of consistency with the 2015 and 17 appeal applications, we state about the requirement for a robust environmental impact assessment, and actually really it was just an environmental impact assessment. I would like that word omitted. I feel it's...
so we delete robust?
Yes, please.
Thank you very much, Mrs. Parks. Thank you, Senator.
Thank you, Mr Thompson. Mr Steele.
Thank you, sir. Mrs Parks, good morning.
Good morning.
Mrs Parks, I'm going to try to cover quite a lot of ground as quickly as we can this morning. If I'm going too quickly, just slow me down, will you?
Okay.
And if you don't understand anything, also, please just let me know.
Thank you.
Now, firstly, see what we can immediately agree about. Conditions, section 75, and the method of controlling the hotel, we're leaving over to another session.
Yeah.
Is that correct?
Yes.
Excellent. And so far as economics are concerned, although you deal with it to some extent, that's being dealt with at the second session as well?
Yes.
Right. Insofar as you refer to matters of landscape architecture, as I understand it, you're not a landscape architect and you really refer and rely on the evidence of Ms Walden in that regard. Is that correct?
Yes, I
so
took that.
I don't ask you any questions about that.
Okay.
Right. And you also rely on the evidence of Mr McMeekin in relation to certain heritage aspects.
That's
Is that
true.
correct? So we can leave that to him as well. So we've immediately saved ourselves about 3 hours,
Well,
Ms
yes.
Parks, which is good news. Now, were you present at the original workshops?
Which workshops do you mean?
Well, there was a series of workshops spoken to by Mr Leslie, and I've entirely forgotten the dates of them, but there were 5 or 6 of them. And am I right in thinking that you did not attend those?
No, I think I attended the very last one just purely as an observer because I was being brought into the project at the end.
But you weren't involved in the nuts and bolts of it
No.
over the period, so you didn't experience firsthand what was discussed, agreed or disagreed about at these various workshops. Is that fair?
That would be fair up to the point of the last one where I just had some understanding of the evolution of the project. But
Now, can we agree this basic principle that every planning proposal, every planning application or appeal has advantages and disadvantages? That there's no proposal that is entirely one-sided. Would that be fair?
that's true.
And your job and the job of the Council and now the reporters and the ministers is to weigh in the balance the advantages and the disadvantages to come up with an appropriate planning outcome
true.
in accordance with the Act. Would that
Yes.
also be fair?
That would be fair. Mm-hmm.
Now, you had the task, possibly unfortunate task, of preparing the report. Is that correct?
That's correct,
In
yes.
relation to both applications
Yes.
and the application for the trust scheme.
Yes.
Now, in relation to the first application, which is document CD 419, can I just establish some basic principles about it, which I hope we can both agree pretty rapidly.
Yes.
Firstly, this document represents your professional opinion.
Yes.
It also was signed off by the director at that time, Head of Planning, Mr John Burry,
Yes.
and it reflected the views and opinions of the entire department. Is that correct?
Yes, it would do. Yes, certainly. Mm-hmm.
And that would include landscape architecture issues and heritage issues, economic issues and the like.
Well, what we do is we take into account the really internal advice from other parts of planning, and at that time, I'm not sure if the economic development was part of our department or not, but we would take them into consideration as a consultee at least.
So to summarise the matter, would it be fair to say that this report represents the professional judgment of the relevant professionals within the City of Edinburgh Council?
Largely, but we have to take into account the views of other internal consultees. At the end of the day, as you say, we have to come up with a balanced viewpoint on the proposals.
And do I also understand that this report went to the committee and they endorsed it, agreed with it, save, I think, for one matter. Is that correct?
They endorsed, agreed.
Did they add another reason for refusal?
On the first application?
In the first application, is that correct or not?
I actually can't remember whether or not that was the case, to be honest.
Well, let's look at your report, if we may, at 419. Stressing that this represents your professional opinion and that of the Planning Department. Is that so?
Sorry, would you repeat that again, please?
I'm looking at 419, which is your report committee,
Yes, okay.
stressing that this represents your professional opinion and that of your department.
And that of my... okay.
I think you may need to speak into the microphone a little bit, Ms. Parks. I'm having a difficulty. I don't know about others. Are we agreed about that?
Yes, I assume so. Which part of the report are you referring to?
Well, I'm referring to the whole report,
Right.
and I'm about to look at the report, but I'm just trying to establish the ground rules first.
Well, it was signed off by, as you say, John Berry at the time, so he was satisfied with the contents of the report when it went before going to the Planning Committee with it.
Well, let's look at the report, please. Page 13 of 136 under the heading Principle. And do we see the first heading there as SPP, Scottish Planning Policy?
Yes.
And it then lists a number of sustainable development principles,
Yes.
which I don't ask you to read, but we all have in front of us. But is the conclusion at the bottom paragraph that the proposal complies in general terms with sustainable development principles relating to the issues that are set out there?
It identifies those ones which it complies with and gives a summary of those.
And is this stated, the proposals are considered to be consistent with these principles?
With the principles listed there, yes, overall.
Thank you. So we can agree, therefore, that the SPP, so far as relevant at that time, the proposal was consistent with the SPP.
Well, with the overall principles, that doesn't mean to say that we agree with everyone in that list there. That's the general principles of it.
Okay, well, let me put it another way. We agree that overall it's consistent with the SPP. Is that correct?
Well, I say what it actually complies with in the list below. Relating to accessibility, owing to its city centre location, where public transport facilities are readily available, the reuse of the building contributes to the sustainable nature of the development, and they would also introduce a high-quality mixed-use development in an underused site, which will promote placemaking and contribute to the economic growth and well-being of the city.
And the proposals are considered to be consistent?
Yes.
Fairly briefly, perhaps
overall.
Too briefly, Mrs. Parks. I apologise. Turning the page, local plan policy at that time, EMP5. You concluded that the hotel use is acceptable in relation to that local plan policy. Is that fair?
Yes. Yes, that's correct.
And that policy is echoed by policy EMP10 in the local development plan.
Yes.
You then go on to deal with policy RET 12 and RET 10 of the LDP. Again, the proposal would be consistent with that. Is that so?
That would be the case, subject to other policy considerations of the development plan, yes.
Yes, but I'm just going through one policy at a time. But so far as this policy is concerned, we're consistent.
Yes, although I have to say, in the case of public houses, we did point out under that policy there's other amenity considerations which are covered under other policies.
Well, whatever this is, I'm not entirely certain it would be a pub.
This part of the report of handling, it deals with it in principle. It doesn't go into the details of it.
I absolutely understand that, but yes. I'm just going through it slowly so I understand it.
Yes.
Right. Now, we then go on to the Block 10 development brief, and you there list the three principles of that. Firstly, to promote the viable reuse of the school and campus for the purposes set out there, visitor facility and cultural destination. Secondly, to enhance movement and access, etc.
Yes.
And thirdly, to respect and enhance the key views to and from the area and protect the setting of the former Royal High School.
Yes.
And do we see in the last line, you say this, Nevertheless, the proposed hotel use is consistent enough with the aims of Principle 1 of the development brief as to comply with it.
Sorry, where was that? That was...
Bottom of the page, last sentence.
Well, I think when you start a sentence with nevertheless, I think it means you have to really read the sentence before it.
Well, please feel free to do so.
Yes.
I hear exactly what you're saying, but I was just kind of cut to the chase, that despite any factors against it, you concluded that it was consistent with the aims of the development brief and complied with it.
That was the interpretation at the time, but it does say the guidance also seeks cultural orientation and information use, as well as museum and exhibition uses.
Yes.
And then it says nevertheless.
Yeah.
Yes.
But on balance, you concluded that it was consistent with the development brief, did you not?
It was concluded that was the case, yes.
And you then concluded at the top of the next page, some 4 lines down, in conclusion in respect of the SPP generally, local plan policy and the Princess Street Block 10 development brief, the proposed hotel use is accepted in principle, subject, of course, to other policy considerations.
That's correct, and other policy considerations are dealt with further on.
Yeah. Well, so far so good for us. Would that be fair?
That would be fair, but I would like to point out, if I may, that the Princess Street Block 10 development brief refers to other issues, which includes protecting and safeguarding the views of the Hamilton building. So that is a matter which would need to be taken into consideration in other parts of the reports of handling.
Let me then take you back, Ms Parks, because I thought we'd covered that. At page 14 of 136, the third principle listed there is to respect and enhance key views to and from the area and protect the setting of the former Royal High School building. Is that not exactly what's said?
Protect key views, yes.
Yeah?
Yes.
And you have concluded that the proposed use is consistent enough with the aims of the principle, which we've just set out above, as to comply with it. Is that so?
I think views are dealt with in quite a lot of detail in other sections of this report, and we do say that subject to other policy considerations. So that's a qualification to say it's accepted in principle, but there are other policy considerations which need to be taken into account further into this report.
Yes, of course,
yes.
Of course. Right. If we go to page 17 of 136, sorry, 17 of 136, do we see some detail there set out, which I'm going to try and take rapidly. The second paragraph, the proposed glazed links were deemed to be acceptable and sensitively handled. Is that correct? That's page 17 of 136, the second paragraph.
Are acceptable in principle, yes.
Yes. And the last few words, visually lightweight and sensitively handled. That was your assessment of the position, was it not?
Sorry, I think...
page 17.
Page 17.
Second paragraph.
Oh, second paragraph.
You're dealing with the proposed glazed links. Do you have the right page there?
I do, but I haven't got that text on it.
Well,
I wonder.
Second paragraph, but does it not begin the proposed glazed links?
Sorry, it may be that this one's set out slightly differently. Right.
So just, I hope it's the same report. It's just a different
all
print
the other
rim.
words you read out were the same. It's just that the paragraphs seem to be in a slightly different place.
Okay, so let's assume it's a different print run rather than a different report.
Yes.
So do you have you found the glazed links now?
Yes, I've got it now. Thank you.
Right.
Yes.
Acceptable in principle and visually lightweight and sensitively handled. That was your judgment.
It says the proposed glazed links to be attached to the rear elevation are acceptable in principle. Through an addition to the rear of the building, though the addition of to the rear of the building is not ideal, the approach adopted is visually lightweight and sensitively handled. Yeah.
Thank you. Now, if you go forward 2 paragraphs, we there see the way in which you've dealt with the new entrance doors.
Yes.
And again, did you deem them to be sensitively handled and acceptable?
Yes, that was the case. Of course, again, I would have taken advice from the listed buildings officer, Ewan McMeekin, at that time on that matter.
Yeah, of course. And in the next paragraph, the issue of the portico, again, that was deemed to be acceptable as well, for the reasons set out there.
Yes, yes. Just if I could just read it through, sorry. I think that, yes, there was some concern about the details of the railings. They're just that a condition would be required there to ensure an appropriate material and detailing. Yeah.
But there was no difficulty. That was all acceptable, subject to a condition.
True.
Right. Now, 2 paragraphs further on, perhaps more importantly, you say this: reinstatement of the retaining wall and belvedere are considered to be conservation benefits.
Yes, and then I go on to say, however, the new building elements will mostly obscure such features when viewed from the south.
Yes, indeed.
Yeah.
Well, just again a sentence at a time.
Right.
Can we agree that these indeed are conservation benefits?
Yes, in their own right.
Yeah, yeah. And do you also accept that one of the benefits is that they will not only be revealed, but their setting will be improved, i.e. the building, which one is it, the classroom building, will come away and permit the retaining wall to be revealed for the first time?
Yes, although, as it does say in the report, the new buildings will mostly obscure these features, but from certain angles.
Well,
yeah.
I don't know whether you've been here throughout the entire inquiry. I hope I don't have to take you to the viewpoints, but there are a number of viewpoints, as I understand it, from which the belvedere will be, to the south, obviously, from which the belvedere will be seen. Were you here? Do you recollect that?
Yes, I think so.
Yeah. And in addition to which, we're going to see rather more of it than we see at the present time. Would that not be fair? Because at the present time we can see nothing.
Yes.
Now, next page 18, did you consider that bringing the building back into long-term future is a significant conservation benefit? Next page, some 5 or 6 lines in.
5 or 6. Yes. That is part of a sentence, though, and it goes on to say the current proposals are not considered to be a conservation-based approach to redevelopment of the site, with the new built extensions impacting on the Hamilton building.
Whether they're conservation-led or not, we have led extensive evidence about that, and the learned reporters will make up their own mind about that. I wasn't going to quibble with you about that, Mrs. Parks, because I didn't think that was your department. Frankly, the conservation issue, I thought that was for others.
I'll agree with the first half of the sentence where we say there would be a significant conservation benefit.
And that is repeated again under the heading demolition, is it not? Now, you also point out in that middle paragraph that the building is on the building at risks register. What weight do you say the reporters should attach to that fact?
I think that's for the reporters to decide.
Well, okay, that's fair. What weight do you attach to it as a very experienced planning officer?
It's certainly a consideration, but you also have to give consideration to the benefits of the application and whether the impacts of the development would be so significantly adverse that they would damage the special interest of a listed building, and it would therefore be not a benefit for it to be used for that purpose.
Well, I understand all of that, Ms. Parks, but tell me this. Some say this is the most important building in Scotland. I don't know whether you agree with that or whether you disagree with that, but in any event, it's pretty important, isn't it?
That's true, yes.
Is it satisfactory for Scotland's most important building, or possibly second most important building, to be on the building at risk register? Is that really desirable from a planning point of view?
No, yes, it's not. It's a case that it's not desirable.
And within reason, anything that can be done to get it off the building at risk register should be very seriously looked at, should it not?
I think that's correct, and that this is why these applications require such scrutiny to ensure that we've got the right solution for such a building.
I think we can also agree about this, that of all the applications you've had, this is probably the application or applications that have had the most detailed scrutiny ever. Would that be fair?
I would certainly agree with that, yes.
There's been no pebble stone has been left unturned several times.
True.
Nothing is going to get through the net here. Would that be right?
That would be true.
Yeah. Now, I'm not going to go into economic issues, but under the heading viability, did you conclude that the conclusions of the viability assessment are accepted? That's at page 22 of 136, 5 lines up from the word location. Do you see that?
Sorry, I just need to read it.
It's one simple sentence I'm putting to you.
I agreed with the conclusions of the assessment of economic viability of alternative uses at that time, yes.
Right. Let's go on, please, to look at the next page, which is the conclusion in relation to the SHEP test.
Right.
Do you have that?
Yes.
Page 23, some halfway down. You accept... I'm going to just try and take this briefly, but if you want me to read the whole paragraph, I will do so.
Sorry, just maybe, if I could just stop you there for a minute, please, because, again, this is all being dealt with through the listed buildings officer, and he would be the expert to interpret the SHEP test. Obviously, I have to be in agreement with it and consider it in my planning application. But that's a lot. He's an expert at deciding the impacts on the listed building and whether that's.
Well, that's no doubt true, Ms. Parks. But I'm asking you questions about your report, which I would hope that I'm entitled to do.
Yes. Unless
there's a real issue about that.
No.
Because you wrote this, didn't you?
Yes. Right. I have written this with. Due consideration to the findings in Mr McMeekin's report.
And presumably this reflected the opinion at that time of whoever it was, the listed building officer, possibly Mr McMeekin. Is that correct?
Yes.
Right, okay, so let's see what was said then. It was accepted that there would be significant benefits to the economy and to tourism.
Yes.
Line 1. Line 4, a hotel of the very highest quality is proposed, and the method of securing that we will deal with at the conditions session.
Right.
High-spending tourists, etc., well, that's more for the economic session. Yes. Sector hotel market does not adequately cater for. Let's leave that to the economic session. Positive contribution. But what you say here is a result, and this relates to the HES test, as a result, the development could make a very positive contribution to Edinburgh's economy and contribute significant benefits to economic growth for the wider region and the nation. These are your words, aren't they?
Yes, I presume so. Well, I mean, my report, having said that, my report, and I have to qualify it that there, it's, whilst it's my report, it does go through an editing process, and certain parts of the wording can be changed as long as I'm in overall agreement with the report findings. So it may not be the exact words I said at that time.
But these represent the considered professional opinion of your department and one which you advanced to the committee and
yes.
which they relied upon.
Yes. And
that included a finding that the benefits would contribute significant benefits to the wider region and the nation.
Well, it says could.
Yes, indeed.
Could. And make a positive contribution, yes. And
a case has been made for the demolition of the listed buildings, plural, that goes some way to meeting the provisions of the test of the SHEP. Is that correct?
That's correct. And that's where I would rely more on the evidence and the findings of the opinions of my of the listed buildings officer colleague, yes.
Let's then look over the page, please. local plan policy ENV2, which relate to total or substantial demolition of the listed building, and the criteria that apply to that policy are listed there. Is that so?
Yes.
And you've listed, you've considered criteria A, B and C together, you tell us.
Well, I haven't. These are criteria that my colleague Ewan McMeekin has looked at, and it's his professional opinion, and I'm not as qualified as him in that respect to do so. So I take those viewpoints into consideration, and it's his evidence really.
So you tell us that this is his evidence that you have reflected in this report at this stage. Right. Because what it then goes on to say is this: the value of returning the main Hamilton building to a long-term future cannot be underestimated. I suspect that might mean overestimated. But passing on, the viability of the hotel proposals is dependent on the demolition of the classroom, gym block and the Gatehouse Lodge. And it is accepted that the economic benefits to the city, region and nation are significant enough to justify this demolition, whilst returning the Hamilton building to a sustainable use. As such, Part A of the local plan policy has been addressed. That means, therefore, that there was an acceptance by you, and it was the professional judgment of Mr McMeekin, that the case had been made that justified the demolition of the classroom, gym block and the Gatehouse Lodge, does it not? That's what it says.
Justify the demolition. In this instance, though, it has been accepted that a conservation-based approach to the Hamilton building could justify the demolition of the gym or classroom block. Yes.
Well, I'm simply reading the words that you wrote, and I can read them to you again if you want. But this seems to me to be absolutely clear that the economic benefits to the city, to the region and the nation are significant enough to justify this demolition, and the demolition that is referred to is the classroom, gym block, and the Gatehouse Lodge. Is that not correct?
We didn't accept that this approach to the works to the Hamilton building would be accepted as a conservation-based approach. We found that in total the effects of this overall development are not a conservation-based approach, and therefore we wouldn't consider that it would justify the demolition of the gym.
Could you explain for me
block.
And to the reporters what that paragraph means then?
Well, really, I think you should probably ask Mr McMeekin that and not myself, because, as I say, he was an expert in that field. That was, and I use that evidence in my report.
That's a little tricky now, because Mr McMeekin is either in the back of the room or he may have returned to Dundee, I don't know. But it's a bit tricky because he's already, well, he may be there too.
As I would agree, the proposals that that are part of this development do not, in our opinion, represent a conservation-based approach.
Well, Mrs. Parks, can we agree that this paragraph, read according to the usual interpretation of the English language, means that you have accepted the demolition of the classroom, gym and Gatehouse Lodge for reasons set out there? Is that not what that paragraph says?
It could justify. It has a potential to justify it if it was a conservation-based approach.
I think we may be at cross purposes, Ms Parks. Let me read it to you again. The viability of the hotel proposals is dependent on the demolition of the classroom, gym block and the Gatehouse Lodge, and it is accepted that the economic benefits to the city, region and nation are significant enough to justify this demolition, whilst returning the Hamilton building to a sustainable use. Now, could you explain to me what other possible interpretation there can be other than that you, and therefore the relevant department, accepted the demolition of these buildings on that basis?
for this application. We accept. Are you saying that you're asking me to agree that I accept that in this case there was a conservation-based approach, and that which would justify the demolition of the gymnasium block?
Ms. Parks, I'm trying to keep it simple. I'm just trying to understand what these words mean.
Well, I think it's talking about the potential.
Well, where does it say that?
Well, when you say could, you don't mean would.
Well, where does the word could appear?
I think we're on different paragraphs. I think that's the problem here.
Could, sorry.
That's why I've been specific to read out the precise wording to you, Ms. Parks, because I don't have, in the bit that I've read to you, I don't have the word could.
Is this where you cite the adequacy of efforts to retain the building in or adapt it to a use?
I'm at the first paragraph, the value of returning the main Hamilton building.
It's the next page, I think, Ms. Parks.
Oh, the next page, right. Oh, no, it is. It's a paragraph above. Sorry.
Well, let's start
be
again,
sure.
Ms. Parks. Maybe
Right.
we're all at cross purposes.
Right, okay.
Page 24 of 136. Do you see about a third of the way down, criteria A, B and C need to be considered together?
Yes.
All right. Let me read to you again the paragraph. Then there'll be no doubt what I'm asking you about. The value of returning the main Hamilton building to a long-term future use cannot be underestimated, which I suggest may perhaps have been overestimated, should have been overestimated. The viability of the hotel proposals is dependent on the demolition of the classroom, gym block and the Gatehouse Lodge, and it is accepted that the economic benefits to the city, region and nation are significant enough to justify this demolition whilst returning the Hamilton building to a sustainable use. As such, Part A of the local plan policy has been addressed. Now, would you like to explain, please, what that means? Because I suggest you it means clearly that you have accepted the demolition of these named buildings.
No, I think it may be an error in how it's been framed, because it's explaining how you would interpret that policy in 2, and obviously the first sentence is correct, and its second is the viability of the hotel proposals is dependent on the demolition of the classroom, gymnasium block and lodge, and it should be if it is accepted that the economic benefits to the city, region and nation are significant enough to justify demolition.
No, Ms. Parks. This
Well,
report
I mean, if
was...
you read the conclusions are clearly not saying that the gymnasium block is the demolition of it is acceptable, and
No. Ms.
because this scheme is not conservation based.
Mrs. Parks, this was in a particularly important application. It was a particularly important matter for the committee, was it not? Are you seriously suggesting that an error of that magnitude was contained in a report that must have been pored over by several officials, not just yourself, but Mr. Burry, before he signed it off?
Well, if we had agreed that, we wouldn't have come up with the conclusions that we have. I accept fully that some of the other buildings on the site are not of such architectural merit, and that there wouldn't be such a case for it. But in the case of the gymnasium block, we wouldn't have justified demolition of that building under the interpretation that we've used.
Well, firstly, can we agree this, that in the plain English of the matter, that has been accepted, albeit you're now explaining that might have been an error?
If you read the reasons for refusal, it's not compatible with that.
And are you saying the difficulty relates to the demolition of the gym block rather than the other issues, other buildings, sorry?
Yes.
So you're quite happy in relation to the classroom and the Gatehouse Lodge?
I would say subject to an acceptable scheme being approved.
Yeah. The issue for you is the gym, not the other buildings?
Yes, that's correct.
And you're quite sure about that?
Yes.
Okay.
The other buildings would still be dependent on an acceptable scheme being approved. But again, as I say, Mr McMeekin is more of an expert in interpreting the fine details of the SHEP policy.
And you then say, as such, Part A of the local plan policy has been addressed. Now, the English of that is perfectly clear as well, isn't it?
Right.
Well, is it, or am I misunderstanding something?
That's
Part A is the... Well, what Part A are you referring to?
as such Part A of the plan policy. Oh, it's only in relation to that. Sorry, I understand it now. That's only in relation to Part A of that test.
Yeah. And what does Part A say?
The condition of the building and cost of repairing and maintaining it in relation to its importance and value to be derived from its continual use.
Yeah. I've got some distance to go, sir. I wonder if this is a useful time to have a break.
Yes, that sounds sensible. Let's break now until 11:35.
It's a lovely, lovely day out there. I'm going to see if we can speed things up a bit and get out into it later. What do you think about that?
Sounds a good idea.
Excellent. Right. Let's go back to page 24 of 136. The next paragraph, to the one that I put to you, ends with this sentence. In this instance, though, it has been accepted that a conservation-based approach to the Hamilton building could justify the demolition of the gym classroom block. Is that the sentence you were keen to take me to?
That's a sentence, I think, I thought you meant that paragraph the last time when you meant the first paragraph.
So, well, that's the sentence you were taking me to. Right. Can we move swiftly forward? Page 34, dealing with the question of design. Now, taking the matter very briefly, do you accept that this is very high-quality design?
I accept that the design solution is a high quality, the architectural treatment is high quality.
Do you also agree that Architecture and Design Scotland, the relevant government agency, are supportive of that design?
Yes, they are supportive, although they did have some caveats on their support for that application in terms of quantum of development.
You set them out there, but the big point is that they're supportive of these architectural solutions. Is that correct?
Yes, the design approach they're supportive of, the type of materials and detailing.
And do you accept that the design solutions cause or contribute towards mitigation?
Yes, well, I accept they do towards mitigation, yes.
And that's for two different reasons. One is the tiering and stepping back of the extensions, and the other one is the use of the materials.
Yes.
Yeah. And in summary, in the next page, you conclude that the architecture is a sophisticated response to the sensitive context, page 35, halfway down.
Right.
Or sorry, just at the end of the section dealing with design.
Mm-hmm.
And it does its best to mitigate, you say, but it's not quite enough.
Yes, that's true.
Turning to page 37, 6 lines down. Yeah. In summary, you found that the daylight, sunlight and privacy aspects were acceptable for all the reasons you set out there.
Yes, we did have an assessment carried out by the applicant on that, and we took those findings into account in coming to that conclusion.
Now, we've already accepted that your professional opinion, reflecting no doubt those of others, are to the effect that the benefits, economic benefits, would relate to the city, the region and the nation, and that they were significant. Is that correct?
Sorry, where are you going to?
Well, I'm actually going back. There's various parts in your document or report that is contained, but in particular it's back at page 24, where you refer to the economic benefits to the city, region and nation are significant enough.
24.
It's a paragraph we were at previously.
benefits.
It's a point we looked at
I think
extensively
if
earlier.
that's talking about the first criteria, that may be the case.
Yeah. The only point I'm trying to take from you is that you accept that there will be economic benefits to the city and the region and the nation which will be significant. Have I got that right? I mean, you said that at various places in this.
In this, yes, in this case, that was the conclusion that was reached, but it doesn't necessarily say significant enough to justify the damage caused.
Well, it's significant enough to justify the demolition on the clear English. Let's look at page 23. Some 1, 2, 3, 4, 5, 6, 7, 8 lines up. Do you not also refer there to the economic benefits as being significant benefits to the economic growth for the wider region and nation?
Sorry, page 23.
23. 1, 2, 3, 4, 5, 6, 7, 7 or 8 lines up.
Well, it says that alongside that, the demolition needs to be considered alongside replacement proposals. And in this case, we don't accept that part of it.
I'm only asking you at this point that your finding was that there would be significant benefits from an economic point of view and that those would be to the wider region and nation.
At that
is
point
that correct?
In time, if we've said it, yes, that must be the case. But I'm just sorry, where does it say to the nation?
This is in your paragraph
yes,
under overall conclusion in respect of SHIP.
Yes. At that point in time, we took that view, yes. But in terms of, but again, it's caveated with the conservation-based approach was adopted.
I'm not asking you about that at the moment. I'm just asking you that I've understood it correctly, what you say the economic position is. Significant benefits and to the region and the nation.
I could just go back here.
Is that not correct?
I think it's a potential for it. And when you go back to looking at it, I mean, it does raise issues. It says potentially support jobs, and it is, however, it is noted that the delivery of the benefits to local community. Oh, sorry, that's. I'm just looking back at.
Mrs. Parks, I don't think this is controversial between us, and I don't want to push you in any way. But is your position not expressed on more than one occasion in this document that there will be significant benefits economically,
yes,
and that they will be to the city, region and nation? Is that not the case? I mean, just tell me I've got it wrong.
That would be the case, yes.
Right. Thank you. Could we then look, please, at the HESPS test, which is document 498. Page 35, please. If we look, please, at paragraph 3.47D, the requirement there is, the question is whether there are significant benefits for economic growth. Now, you have already found that there are significant benefits to the city, the region and the nation. It must therefore follow, must it not, that the significant benefits identified here at 347D have been met.
Sorry, just a minute, please. Yes, that's correct, yes.
Thank you. And it must logically follow, if we go to 348C, where the same words apply, significant benefits to the or very, very similar words, sorry, significant benefits to the economic growth, we must be able to agree, surely, that that has also been met, that part of that tests.
That was, yes, that was the opinion, yes.
Thank you.
Certainly part C, yes.
Thank you. Now, I'm just turning on further in your report, if I may. Could we go in your report to page 47?
Could I just, before you go there, I just would like to qualify that with, however, that when you read the overall conclusions in relation to SHIP on page 23, that we say it goes somewhere towards it, but also the demolition needs to be considered alongside the replacement proposals.
I'd moved on to the HESP
Right.
test and particular parts of it, and we've dealt with that
Right.
now.
Okay, thank you.
Right. Can we go, please, to 47 of your report? And do we there see, in summary form, the extent and range of the nature of support for this proposal?
Well, that gives you the matters that have been addressed in it, but I think there's details about the numbers of people. I think you'll find significantly
Mrs.
more.
Parks, I'm not for a
objection to it.
second suggesting you haven't dealt with it, but this is a nice summary part to look at. So could we look at that, please? Now, the first four relate to economic issues, so I'm passing on them until session 2. But do we then see there's another 10 or so, 3, 4, 5, 6, 7, I can't count it, 7 issues that have been raised as positive aspects in favour of the proposal: antisocial behaviour in Carlton Hill, returning of the building to sustainable use,
Yes.
provision for future upkeep and maintenance, sensitive design of the new build and the interventions, good quality, responsive design, positive impact in the setting and compatible with the site setting. These are all representations that were made in favour of the proposal. Is that
Yes,
correct?
and they have to be balanced against the
Of course.
other.
And the bottom line is this,
taken.
that some people will love it
Yeah.
and others might hate it. And some people might like a hotel idea and others might think it's rather vulgar, I suppose.
This is
That's
very
possible.
possible.
Yeah. And some may even think it looks like a gas container. Is that correct?
Yes.
Now, as you said in that report, you summarised the position very well because you stated, put simply, the building was too big. Is that correct?
That's correct.
Yeah. And that was the position
At that time,
at
yes.
that time. And as a result of that, my clients addressed the issue and came back with a proposal that was smaller. And I'm not going to go into the detail with you, but as a matter of fact, it was smaller, and they would say, and I say, significantly smaller. Is that not correct?
It was smaller, yes, but from our viewpoint, not small enough to address the concerns in relation to scale.
And that's why we're here, isn't it?
Yes.
Right. So could we please go to your next report, 425. And again, this was a report written by you, endorsed by your department, but this time I think signed off by Mr. Leslie. Is that correct?
That's correct, yes.
Now, I can go through the thing in detail if needs be, but do I note there's a different tone in this report, one that is perhaps less enthusiastic about the proposal?
Well, I think there was probably some disappointment that it wasn't reduced further in scale, and that is why we weren't able to give the positive recommendation that we would have hoped for.
Now, just on the question of recommendations, in relation to the first report, some of the report is really quite favourable to the proposal. Was consideration given in terms of the first report to making a recommendation for approval?
By the committee at that time.
No,
yes.
In the report.
In the report,
Yes.
recommendation for approval.
Was there consideration given at any stage during the formulation of the report to making a recommendation for approval?
Well, it depends what you mean by formulation of the report. When a new application comes in, obviously we start assessing it from the beginning, and we would always look at it with an open mind to begin with, and take all considerations into account in reaching a balanced viewpoint. And that is what we did, even though we had some reservations about it. We had to look at the findings of the environmental impact assessment, and as you say, the responses of the public, and also, very importantly in this case, the concerns of other relevant consultees, especially the statutory ones, in reaching a balanced viewpoint, and that is hopefully reflected in the report.
Well, all of that is true, but at any stage in the processing before the final report that we see before us, was a consideration given to making a recommendation for approval?
Well, while I was writing that report, I'd already carried out my assessment in some depth, and I think I find in this case that the 17 application had a longer timescale when it was under determination, so we had some time to think about it and to ensure that we reached a balanced viewpoint, and we're happy with the recommendation. And at that point, when I was certainly when I was going through my final parts of the assessment, I was quite of the viewpoint that it would be for refusal.
I think you were referring to the 2017 one, is that correct?
That is correct.
Let me take you back in time, because I'm really asking about the 2015.
Right.
Now, was there a stage in that process where there was a feeling that approval might be the correct outcome?
I would say not. Again, as I say, we kept an open mind while we were considering the responses from relevant consultees and the public, and doing our own analysis of the environmental impact assessment and so forth. But when we got to the stage of writing up the application, certainly I would say, from my point of view, it was quite clear that I would be recommending refusal.
Did you have any direct contact from HES about either of the applications?
Sorry, what do you mean by direct contact?
Well, did anyone in HES speak to you about either of these applications?
Well, we spoke to HES about the findings of the environmental impact assessment, and just in terms of understanding them and whether we thought we'd got enough information.
Would it be fair to say that HES were quite strongly opposed to both of these applications?
They were, and they are a statutory consultee, and we have to take their
and
concerns
you therefore
give
placed,
them significant
and there's
weight.
no criticism of this, but you placed a considerable weight on the strength of their opposition.
Well, we would have to. In this case, it's a Category A listed building, and they would have the right to call it in if we approved it, and it requires.
And you had that in mind, that their right to call in if there was to be an approval?
Well, that was certainly one matter that we took into account, yes.
I mean, I don't want to put this, to overstate this, but is it fair to say that the outcome, your conclusion, was pretty strongly influenced by historic HES's very strong opposition to these proposals?
We would take it into account, but certainly we would form our own opinions as well. And it was very clear from the drawings and the impacts found through the environmental impact assessment that, in our opinion, the buildings were too great and they caused too much widespread damage to the appearance of the building and to the character of the conservation areas and the World Heritage Site. So it certainly wasn't just the response from Historic Environment Scotland that we based our decision on, although that was an important consideration.
It was an important consideration. You attached some considerable weight to that. Would that be fair?
Be fair, but also we did to the views of Edinburgh World Heritage and to SNH, who are also quite concerned about the application in terms of its impacts on the special landscape area and the landscape of Calton Hill.
Now, in your second report, matters had moved ahead and you devote a section to the Preservation Trust scheme, which by then was consented. Is that so?
Yes.
And would I be right in thinking that you have placed some reliance on the existence of that scheme in your determination of our proposal?
Well, we looked at it in terms of planning applications. We really just in terms of looking at potential other uses for the site. So in terms of considering the planning application, it was more to do with really generally the educational use could be a conceivable alternative use for the site, and we asked that to be taken into account in the study of alternative uses that the applicant provided. So
you asked us to take that into account, which we did.
Yes.
And you placed some reliance on the existence of the Preservation Trust scheme in determining our application.
From the point of view of whether there would be an alternative use that could be possible at that site, it could be feasible, and they were demonstrating that there could, through their drawings and through their submissions, that it would be potentially possible to convert it to such a use, and there may be a demand for that use. In terms of the listed building consent, that was a different matter, because it would be considered, as you point out, on the Hesper's tests.
Yeah, indeed. But you concluded that the granting of the applications which have been granted by the stage of the determination of our second application was evidence enough in planning terms that there's an alternative beneficial use for the site. So, I mean, to take the matter brief, Ms Parks, you thought because there's another beneficial use which some people preferred, then our scheme had little prospect of progressing.
Sorry, could you just tell me which paragraph or which page of the
report
that was?
Page 24.
Page 24.
1, 2, 3, 4, 5, 6, 7 lines down.
Okay, thank you. Again, we're talking about the Hesper's policies, which really is relevant to the listed building application. These are matters really that relate directly to that, and for the purposes of making clarity, we've added it into the planning application. But
if it was only relevant for the listed building application, why on earth is it in your planning report? Well,
because it helps explain how it helps interpret policies ENV 3 and 4 of the Edinburgh the Edinburgh Development Plan.
Yeah, indeed. So it was relevant to the planning consideration, wasn't it?
It was relevant to the Hesper's test, but the fact that it was compliant demonstrated, in other ways, demonstrated that, not compliant, demonstrated that policy ENV4 wasn't met.
Yeah. And of course, if the truth of the matter is that there is no prospect, and this is hypothetical at the moment before anybody starts jumping in, if there was no prospect of the music school or the trust proposal proceeding, then you would have written the proposal. You'd have written the report in an entirely different way, wouldn't you?
Well, that's a hypothetical situation. I would have had to consider it in those circumstances.
Yeah. Yeah. I mean, do you anywhere in this report mention the small little detail that another party, namely my clients, had at that time got a binding legal contract over the site?
That's not a material planning consideration.
Well, isn't it? Because in terms of the HESP test, it most certainly is, surely.
Well, as I've just explained, the HESPA's test is more for the listed building consent application. It's not a planning issue.
Well, is that really right? I thought you told me that there were development plan policies relating to the availability of an alternative use. An
alternative use? Well, yes, in terms of alternative use, but not in terms of whether, if I could just go to policy ENV4, if you don't mind.
CD 455,
Yes.
policy ENV4 on page 36.
Yes,
I've got.
thank you. Well, ANV4 just says those alterations or extensions are justified. There's no unnecessary damage to historic structures or diminution of its interest, and where any additions are in keeping with other parts of the building. Sorry, it's ENV2 actually, which is on page 99. So it says the merits of alternative proposals for the site and whether the public benefits to be derived from allowing demolitions outweigh the loss. In terms of merits of alternative proposals, we've looked at alternative proposals, but it doesn't require us to assess the viability of it, as far as I can see from that policy.
But surely you have to consider whether there are viable alternative proposals.
It doesn't require it under ENV2.
So notwithstanding a situation in which an alternative proposal may have no prospect whatever of proceeding, are you seriously suggesting that would be a relevant material consideration?
Viability of a planning application is not a material planning consideration.
Well, it's certainly relevant in terms of the HESP test, is it not?
Well, as I've explained, that's to do with the listed building consent application.
And the HESP test are a material consideration in the determination of these applications, surely?
Only in the planning application insofar as it relates to those parts of the policy provisions for ENV4. I'm sorry, ENV2.
So we can agree that there is some relevance in that regard. Is that so?
Yes.
Thank you. Now, to take you back to the main point, if there is no prospect of the trust proposal ever being implemented, may I take it that you would have written this report in a rather different fashion, because you wouldn't have referred to it and relied on it?
I think that's only true to quite a minor extent, in that we have, as you say, we've had to take it into account in parts of the HESP's test, which is more related to the listed building. So it's, as far as the planning application itself is concerned, it isn't a very significant part of it. The planning application is more concerned with the impacts of the development itself, the new development on the building itself and on the wider environment. So,
Ms Parks, I may be wrong, but have you not devoted more than 2 pages in your report to the Trust's proposal at pages 22, 23 and partly at 24?
I don't think that's all to do with the Trust proposal.
Well, let's look at it, please. Page 22.
Well, as I say, that's all to do with the interpretation of the HESP's policy. That was an editorial decision by my manager to include that section within, which is more or less a duplicate of what is in the listed building consent application within this, within the planning application body, for to allow the full reasoning to be considered.
Firstly, can we agree there's more than 2 pages of this report, which I thought you had written, which deals with the music school or the Trust proposal? As a matter of fact, that's accurate, isn't it?
No, it's not. It's not accurate in the sense that, as I say, it is. If you look at the listed building report, you will find the majority of that text will read the same.
Maybe my fault. I thought I was looking at your report, which is CD 425. Have I got that right or wrong, Ms Parks?
That's correct, but as I say, it was an editorial decision to put that duplication of that text into the planning application report, and it only is relevant insofar as it relates to the interpretations of the relevant parts of ENV2.
Let me just take this a stage at a time so I can understand it, Ms Parks, because I'm completely bamboozled. At page 22, do you deal with the Trust proposal?
It's under the interpretation of the HESPS policy point C, of other options for use of the building.
Yes, I can read that,
yes.
But do you or do you not deal with the Trust proposals at page 22?
As I say, that is a repeat of basically of what is in the listed building application.
And at page 23, does that also deal with the trust proposal?
Yes.
And at the top of page 24, does that also deal with the trust proposal?
That's correct. It's still under the...
Are you saying that this should not be in this report?
It's in the report for the purposes of clarity to ensure that we've got an all-round assessment of the applications and
Are you
explaining
saying
how it relates to the policies, the relevant policies of the development plan in respective listed buildings.
Are you saying that it is relevant or not relevant to the planning determination of matters?
Most of this is, well, I'd say it's a generalisation, but the parts where it relates to the viability of the music school are not relevant to the planning application.
Well, regardless of the viability, you've got 2 and a bit pages dealing with the school, dealing with the proposal, what's intended, and so on and so forth. Are you saying that's relevant to the planning report or irrelevant?
Well, some of the economic considerations would be relevant if we considered that of this scheme in itself would be relevant in terms of economic benefits, insofar as if we decided that there was many damaging impacts and it could be a potential overriding consideration. But the aspects related to St Mary's Music School and the economic viability of it are not relevant to any development plan policy. For
do you say that the existence of the planning consent in favour of the trust was relevant or not relevant in terms of our determination?
Only insofar as it relates to ENV2, which it talks about the existence of alternative uses.
Well, why does it not appear in that context? Why does it appear in a completely different context altogether under the heading HESPs?
Well, I'm afraid that's where it was, but that is how I've explained to you that it's the reasons why it's there.
Do you say that it is an error to have included this with this heading
it's
in
not
this?
an
Let me just
error.
finish. Within this planning report, which was edited in by somebody else.
It had been put in there, yes.
Pardon?
It has been put into that report, but
Well, I know it's been put in, but are you saying
it is really to do with the listed building application?
Are you saying it's an error to have this in here in this planning report?
It demonstrates that it doesn't comply. Therefore, it explains why it's contrary to the development plan policies.
No, Ms Parks, this section is under the heading of HESPs. It does not refer to the development plan, does it?
Well, it is evident as the conclusions are relevant in terms of it explaining in planning terms that there's an alternative beneficial use for the site which comes into play in policy ENV2.
But where in these 2 and a bit pages is ENV2 even mentioned?
Well,
No, in the 2.5 pages we're looking at, pages 22, 23 and 24. Where is ENV2 even mentioned? Can we agree swiftly it is not?
ENV2, it's mentioned on page 16.
Well, I know that,
Yes.
Mrs Parks, but at pages 22, 23 and 24, where you deal with the trust proposal, it is not mentioned, is it?
No.
It is only mentioned in relation to HESPs. Now, do you say these 2 and a bit pages were an error appearing in the report, or do you say that they should have been there?
Well, perhaps it should have been there as well.
Pardon?
It probably should have been there as well,
It should have been there as well.
possibly.
As
But the main points of this of pages 22 to 24 is talking about HESP's policy.
Yes, I realise that, but my question is this. Are you saying that's a correct inclusion in the report, or was it an error?
Well, it's demonstrating why we can't accept. I really don't know. I would have to.
You don't know? Okay.
But
well, let's leave it on that
there.
basis. You're the author of the report, and you don't know whether these 2 and a bit pages should have been included or not.
No, they're in there as explained, because that is our practice to put them in to explain how we've considered the impacts of the proposed alterations and extensions on the listed building. And the HESPA's policies is relevant because it demonstrates whether or not there's compliance with the development plan policies relating to the protection of listed buildings.
How can it assist in deciding anything in relation to the development plan? Could you just help me with that, Mrs. Parts?
Well, if you consider the impacts on the building as required under HESPs, and go through that analysis, it therefore would help to demonstrate whether or not there are harmful impacts on the listed building, which would demonstrate that it doesn't meet the requirements of HESPs and other matters, and therefore that it cannot be justified and under the policies of the development plan.
Well,
relevant policies of the development plan.
Let me, if I may, ask you a couple of other questions. If we go to the bottom of page 23, we see this. The applicants have provided a structural report that suggests such work, this is the excavation work, cannot be undertaken without damage to the building. Now, that is damage to an A-listed building in the southern facade that was an issue. Is that correct?
Sorry, page 23, is that last paragraph?
Last paragraph, some 6 lines up. I'll repeat it to you. Do you have it now? The applicants, 3 lines into the paragraph.
Yes.
The applicants have provided a structural report that suggests such work cannot be undertaken without damage to the building. You see that?
Yes.
And do you understand by that it was meant the structural work underneath the portico?
Yes.
And the concern was of possible damage to the portico itself and the surrounding facade?
Yes.
Do you understand that was what was referred to?
Right.
Right. Now, you then say this. This assessment lies outside the realms of planning control. Can you explain why it would not be a planning issue if there was a risk or even significant risk of damage to the portico and the surrounding facade? Surely that must have been a planning consideration.
Sorry, this is the bottom of page 23?
Yes.
Yeah.
And your words.
Sorry, I can't see where you say it's not a planning consideration.
what you say is this assessment lies outside the realms of planning control.
Correct. Yes.
Now, surely it was a matter for a planning assessment as to whether there may or may not be such damage and a consideration to be taken into account.
Well, we're not structural engineers, and we wouldn't we wouldn't have the responsibility to carry out that work or to undertake that assessment ourselves. That would be a matter for a building warrant.
So, from a planning perspective, you simply ignored that issue of risk, if there was one?
Well, it would be up to them to demonstrate that they were able to undertake these works, and as I understand it, they would have to submit the details to the building standards part of the council for a detailed consideration of that matter.
Now, on another issue, am I right in suggesting that either you recommended or the committee suggested an expiry date for this consent, the consent for the trust for 7 years?
I think that's correct. It was subsequently agreed.
Sorry?
It was agreed, yes.
And why was that? That's an unusual length of time, isn't it?
Well, presumably you would know the reasons for that, because there are constraints to the, I suppose that they do not feel that they would be able to implement the works at this this time period, because obviously it's not within their ownership, so they would be wanting a longer period in order to carry out the work.
Firstly, is 7 years a usual period to impose for a condition?
It's not usual, but we do have the authority to allow such dispensations.
Of course. Have you ever imposed a 7-year time period before?
I don't recall 7 specific years being.
And the purpose, just explain again what the purpose of that highly unusual, possibly unique circumstance was. Could you just remind us, Mrs. Parks?
Well, it's because of the applicant's constraints.
So because the applicants had constraints, and what are the constraints that you indicate?
Well, I can only assume that the constraints were to do with the potentially. I would have to look back to the committee report that actually mentions that, because it may be in part due to the fact that they don't own the site at present, but also it could be other considerations that they would have, logistical considerations. Okay,
would you like to identify to us then, please, what the reasons were? Do you need to look at the report?
Look at the committee report
well,
for that.
Please,
yes.
Please do. It's document 757.
Thank you. Thank you very much.
To try and save time, Mrs Parks, if we look at the back of the report and your suggested conditions, is there any such condition suggested?
I think this must have been put forward at a later stage at a different committee. That may be the reason.
There's nothing in your committee report suggesting 7 years,
No.
Nor is there any reason for it.
That's correct, yes. But I think there was subsequent committees to that one, so it may have been agreed at that.
So somehow, in a way that we don't, or you, please explain it if you're aware of it, but somehow the 7-year condition at some stage was imposed.
Yeah, I believe so.
And do you understand that is because of the lack of ability by the trust to have control over the site?
I don't know what. Yes, well, I'm speculating that probably is the case because I don't have the evidence before me.
And so there was full knowledge that the trust could not access the site at that time.
Yes.
Now, in relation to your report, was there also a suggestion of a Section 75 agreement?
Yes, there was.
And that was a local little difficulty, was it not? Because, of course, the trust couldn't sign that Section 75 because they had no interest in the site.
Yes, that's true. And
is it also accurate that the council found a way around that by entering into a different type of agreement?
It's quite a common use that, where in a case where a situation like this arises, where the council actually owns the land, that we do use a Section 69 agreement.
So there'd be no difficulty of using such an arrangement with us then, would there?
Well,
no.
Potentially. I mean, if the proposals, the application was approved.
Separately, can you tell me how quickly after the committee the actual consent document was issued, and at what time of day or night? That is for the trust proposal.
I'm not aware of the time of day or night. I know that they were looking to sign a Section 69 agreement at a certain stage, but I can't recall exactly when.
Well, would it be fair of me to characterise as what happened is that the consent was rushed out in double quick time? Would that be fair or unfair?
You seem to have some knowledge in the subject, so I would defer to you on that.
Well, do you know yourself?
I wasn't part of that process. I know that I was involved in preparing a report to a committee to allow to request that a Section 69 agreement be agreed, but not to the actual process of having that signed.
In the first instance, did the committee not extend the period to allow the Section 75 to be resolved?
That's correct, yes, yes.
And then when there was a realisation that that couldn't be done, the matter was dealt with by another way?
That would have been it, yes.
And then the consent was issued pretty rapidly, was it not?
I understand that might be the case.
I think you know that, Mrs Parks, do you not? Judged by the smile in your face.
Well,
no criticism
again,
intended.
I had nothing to do with that actual part.
Not suggesting it's anything to do with you, whatever. I'm not suggesting you did anything wrong, but you know that was rushed out in double quick time, don't you?
I don't know about double quick time, but I know that
rapidly.
There was some agreement reached. Yes.
Now, can I please just return to our consent, or our application, unfortunately not consent, our application, and that went to committee.
Yes.
Did you attend that committee?
Yes. Is this the first or the second?
No, this is the second scheme.
Yes.
And there was considerable debate at that committee, is that fair?
That's true, yes.
Could you look, please, at APP 4?
Thank you. Thank you.
Now, this is a newspaper report, and you can tell us if you don't think it's accurate. But what this says is that the chairman, the then chairman, or planning convener, I should say, stated that the design was almost universally reviled. Now, firstly, in relation to the design, was that the opinion of A&DS Architecture and Design Scotland?
No, not as far as I understand.
Was it the position of the officials of the council?
It was the unanimous decision of the council to reject the application.
That's not the question, Mrs. Parks. So far as the design is concerned, what was the position of the officials? We've been through it earlier. I can take it back if you like. Take you back to it if you like.
I believe that the convener of the planning committee maybe expressed his personal opinion when he was concluding, but I think the councillors took a decision, a balanced viewpoint, and each of them came to their own decision on their views on it.
That's a very wise response, but let me ask you this direct question. Do you think that what is reported here, attributed here to the planning convener, is a fair representation and a fair reflection of the design of the building? Or has he significantly overstated the position? I
think what Lewis Ritchie said was more or less my recollection of it, but when it says it's been and true, it was comprehensively rejected by the councillors.
That's not the part that I'm asking you about. I'm asking you about almost universally reviled.
I don't know where the mid claims the design was almost universally reviled, what that quote comes from.
That's being attributed to him. And can we agree that that is inaccurate and significantly overstating the position?
From my recollection, I'm afraid I don't. I was in a hot seat that day, so I probably wasn't really taking in the full wording of it at that stage, because I did have some concerns. But I can't remember those exact words being used.
Can we agree this, that these words, almost universally reviled, are neither accurate nor a fair reflection of the design?
I think where it says almost universally reviled, I cannot remember those words being used.
No, I understand that, but let's just assume they were used, because that's what's in the article. Can we agree that these are significantly overstating the position and, frankly, should never have been used?
I think to say the design was almost universally reviled, yes, maybe, but I do remember that most of the councillors stated their strong concerns about it when they did their summing up.
We'll leave it on that basis. I don't wish to push you any further on that matter.
Thank you.
Now, can we turn, please, to the trust proposal CD 757, which you may already have before you.
Thank you. Thank you.
Now, insofar as what is written in here about the effects on the structure of the building, do I understand that you're relying on the input of others?
That's correct.
In which case I will not ask you questions about that.
Thank you.
So where you've talked about the portico and the quarrying, I think not blasting, but quarrying or rock removal underneath that, etc., that all's relying on advice from others. Sorry, that's at page... I should have said, that's at page 15.
Page 15. Is it the second paragraph from the bottom?
It is the third and second paragraph from the bottom.
We would certainly be concerned about visual impacts, and we have considered, well, visual impacts have been considered in terms of the assessment of that aspect of the design.
Yeah, but is this your evidence to ask you questions about it, or actually, or are you relying on others?
This is part of my evidence, yes.
Right, okay. Well, insofar as the formation of the new entrance below the portico is concerned, do you accept that that is one of the significant disadvantages of this proposal for a variety of reasons?
I can understand concerns about that in terms of the integrity of the listed building, but in terms of the which is dealt with under the listed building application. But what we do say is that the new entrance and terrace would be masked by the retaining wall and would not be visible from Regent Road, and it's in a discrete location and sensitively handled. So we conclude that it doesn't have an adverse impact on the character of the listed
But
building.
do you understand that there are wider concerns than that in relation to the whole principle of having an entrance on the southern facade?
Well,
that's separate, of course, from the physical alterations, is the principle.
of having an entrance, well, I think it would allow the building to be used for the purposes of the concert hall, which was seen as a beneficial use, and it's discreetly handled. So the overall.
But did you hear the evidence of Mr. Wright? Were you here at that stage, Mrs. Parks?
Yes.
Right. And are you aware of the consultation response from Historic Scotland? I mean, at the very least, this is a significant concern, opening up the southern facade and taking out the amount of stone and underbuilding that there is.
Yes, and it was a carefully considered assessment that we undertook, taking that into account, yes.
And insofar as the issue at the top of page 17 is concerned, the prevention of the north facade from being read coherently, is that part of your evidence, or does that rely on the evidence of others?
I think that would these parts of the evidence generally have been agreed following discussion with the listed buildings officer, and who's taken it into account in his assessment. But I do agree that about the overall conclusions, that the elevation is a rear elevation, and we accept that it is of significant merit. Yeah.
What do you understand will be the public access to the concert hall, and how will that work? Mrs. Parks,
well, I don't
do you
have
know?
the detailed drawings in front of me, but I understand the concert hall.
Sorry, wait a minute. I think we're at cross purposes.
Yeah.
I'm merely asking you about the question of the public, not the physical method of entry,
right.
but what members of the public will be able to access it on, and how often and on what occasions.
Yes, because it would be used by St Mary, the overall building would be under the control of St Mary's Music School. It would be up to the music school to determine when and how often the building would be used as a concert hall, and we've acknowledged that in our report.
So do you know whether that would be weekly, monthly, or on Christmas Day, or once a year, or whatever? Do you know that?
I think they may have given some supporting information, but either way, in that respect, we couldn't enforce that as such.
So the truth is, you do not know, nor can you enforce the extent of public access to that concert hall. Is that so?
That would be true, yes.
So far as you're concerned, it may be that the public would never get access to it. That's a theoretical possibility.
It's a theoretical possibility, but I would imagine when you go to that level of investment, you would want some returns for your investment, and the Trust have said that they would rely on some of their revenue.
In a sense, that's an error in the situation, because we're told that the Trust is so wealthy it doesn't require any returns from any amount of money. So that may not be a consideration here, Mrs. Parks.
Well, you obviously know more about the Trust fund.
I know nothing about the Trust. I only know what we've been told, that they don't require, Mr. Innes assures us that they don't require any return on their investment at all.
Well, I think that potentially that might have been to do with the works to the building to allow for the development and the running of it, but Certainly, I know that they have stated that they would, and so I'm sure that it was mentioned that they would be, this kind of revenue would be taken into account.
And you, in relation to the issue of lighting here, imposed a lighting condition?
Yes.
And there's no reason why we couldn't have a condition about lighting either, is there, if that was deemed to be necessary?
Yes, and there are differing viewpoints on that. I mean, certainly we can require a lighting strategy and some obligation on the owners to implement that, but longer term there are issues with enforcement of a lighting strategy. And
you've got the same enforcement powers against the Trust if they ever proceed as you would against us, and you also have the additional factor that the council are the landlords. What possible difficulty could there be? Well,
aside from the difficulties with the landlord, there's quite a lot of lighting that you can put up without planning permission. You can have floodlights which are discreetly located and still.
Is that not exactly why there should be a condition to have a lighting strategy?
Yeah. Yes, that's true. I mean, it would require listed building consent and possibly conservation area consent, but it depends on whether it's a freestanding structure or not. So there are certain types of lights you could install without.
Ms. Parks, if we agree to a lighting strategy, then you've got control over the matter, surely. Is that not fair?
If we have the building, yes, if the landlord should be able to control that, but not specifically planning.
Let's just deal with that on a sensible basis, please. Now, in relation to the trust and privacy, could I turn you to page 28 and 29 of your report? And do you accept that as a result of the rooftop playground areas, there will necessarily be loss of privacy to the neighbouring residents as a direct result?
The building is slightly further back. This the music school building, the accommodation on that elevation are high-level windows. I think it explains it in the report somewhere. And also the building, well, I think that's the main issue, is that it's high-level windows, so there wouldn't be such an impact in that respect.
Well, let me suggest to you the main issue actually is the playground.
The playground, yes, and that was an issue, although, again, we looked at that some consideration, and the railings would be above a 1.5 metre parapet on this part of the roof, so that does give some privacy to some extent.
Is that really right for the entire length of the playground, Mrs.
They've also
Parks?
got railings above. There was potentially some discussion on a hedge there. I'm not sure if that was actually a hedging along there, but I don't know if that actually came to fruition from memory.
Mrs. Parks, I can take you to the plans if necessary, but is it not the case that so far as the playground is concerned, part of its length, around half of its length in a north-south direction, is surrounded merely by railings, and that the playground goes hard up against the east boundary of the site?
This is true, yes, although we did take into account that quite a lot of children using the playground would not reach the height of adult eye level.
Reach the height of what?
Adult eye level.
But how does that affect noise and general privacy issues? They would look through the railings, wouldn't they?
I suppose potentially they may. Mm-hmm.
Well, it's virtually inevitable, isn't it?
Well,
can we agree this, Mrs. Parks, that in relation to privacy, there is an issue arising from the rooftop playground areas, which are hard up against the east boundary and to some extent only separated by railings from Regent Terrace?
There was a view taken that would be that this would be an acceptable solution, and we do accept that it would not provide full privacy screening above eye level.
You say here the solution also takes account the fact that significant children using this playground will not reach the height of adult eye level. Just forgive me, but what does that mean? Does it mean the children are smaller than adults?
Well, it means that it's 1.5 metre parapet wall below that. So the eye level of some children may not reach that.
But am I not right in thinking, I can get the plan if necessary, that there are only railings at certain parts there?
From looking at it on site, I do remember there being a parapet wall there, and we discussed it at some length with the councillors.
Mr Steele, is this strictly speaking an issue for this inquiry session?
Some lighting and daylighting is being dealt with by written submissions, sir. There's still a question of the impact in terms of the HESP's tests, so I would submit that it is relevant, in addition to which a number of the residents are concerned about privacy, understandably from the hotel, and it may be appropriate that they should realise that there are issues arising from the trust scheme as well.
I appreciate that. Happy for you to continue, provided there's some relationship to what's before us in inquiry session 1.
I do believe, sir, that there is. I'm not going to take much longer. I'm just going to look, if I may, because I'm intrigued. And I really won't be much longer. I think it's 7 or 7. I've got the wrong plan. 714. Now, very, very briefly, Ms. Parks, 714 is the plan, and that seems to show railings immediately on top of the playground area on the south elevation, but they also extend, I suggest to you, partly up the east elevation as well. They go round the corner. And if that's the case, I just simply don't understand that sentence. The solution takes account of the fact that a significant number of children using this playground will not reach the height of eye level.
I would probably need to see the plans of the playground area at that level to get a full understanding of that. I mean, I wasn't prepared for this level of scrutiny of an application that isn't within the scope of this part of the inquiry.
Okay. Now, let's leave that to one side. Architecture and Design Scotland, we've already agreed about. Economic cases going to the second session. Lighting, we have considered. Just give me a moment, please. Can I just take you to your report at 10:43?
My report, sorry.
Do you have that?
Yes.
Can I, just reading this sentence slightly short, the western extension would truncate views of the monument, and the monument you're talking about is Nelson's Monument, from the approach from Regent Road to Waterloo Place. Could you just explain that, please?
If I could have the view, that would be EIA view, that would be useful. Thank you.
Now, the view you refer to is 21C.
Yes. Oh, sorry.
Now, what you've actually said in the text would truncate views of the monument on the approach from Regent Road to Waterloo Place. Is that travelling in an east to west direction?
That must be, yes.
Because in this photograph, 21C, which is your reference, the western extension simply would not feature.
Apologies. That should be 21B, which you get a different perspective from, and it is approaching from...
I see.
Yes.
Right, so 21C, we can agree there's no issue of any description.
But 21B is an issue.
Right.
Okay.
Fine, Mrs. Parks. No further questions. Thank you.
Thank you.
Thank you, Mr. Steele. No questions from us so far. Mr. Thompson.
Thanks, sir. Just two very brief matters. Mrs. Parks, I wonder if I could take you back, please, to the report to committee on Scheme 1, which I think is CD 419.
Okay.
It's the 17th December 2015
Thank you.
report.
2015 report. Yes, thank you.
Now, this will be becoming increasingly familiar by now.
Yes.
You were taken at least once, I think, to page 23. And there are some numbered statements at in a list at the top of the page, and then just below halfway there's a heading, overall conclusion in respect of SHEP.
Yes.
And of course that was the relevant
Yes.
guidance at the time. And then there's the paragraph that I think you've looked at before. And I just want to read you one sentence and then ask you a question about it.
Yes.
Near the end of that paragraph, there's a sentence, as a result, the development could make a very positive contribution to Edinburgh's economy and contribute significant benefits to economic growth for the wider region and nation.
Yes.
What I want to ask you is whether the word should be could make a very positive contribution, or whether it should be would make a very positive contribution, in your opinion.
In my opinion, well, my opinion would depend to some extent on the advice of others, and in my opinion, it would be could, because I'm not aware of what the full extent of the economic benefits would be.
Thank you very much. The next point concerns the Section 69 agreement in relation to the trust and music school proposal.
Yeah.
And I just want to ask you about the factual position, and if you don't know, please tell me.
Right.
Can you tell us what the Section 69 agreement related to? What was the subject matter of it?
It related to sums of money for the traffic regulation orders.
And was the Section 69 agreement concluded before planning permission and listed building consent were issued?
Well, it would have been concluded, yes, for the St Mary's Music School before it was issued, yes.
And was the money to which that agreement related paid before or after planning permission was issued?
I'm afraid I'm not certain about that, but I would assume it. No, I couldn't say for certain on that. But
what would be your normal practice?
normally, you would, yes, you would have the payment, probably. I know. I think I would have to defer to others on that. Just certainly, there would be an agreement, and the agreement would be signed. But whether the monies are paid, I would assume
if you
it
don't know
normally.
that, if you don't know,
Yes,
that's fine.
yeah.
Thank you very much,
Thank
Mrs.
you.
Parks. Thank you, sir.
Thank you, Mr Thompson. Thank you, Ms Parks. You've earned us an early finish
Oh,
today,
good.
for which we're
That's
grateful.
great. Thank you.
So, is there anything that we need to discuss before we close for the week, Mr Steele?
Simply just to double check, I may already know this, but I think I've forgotten that the order of witnesses from HES.
Yes, sir. It'll be Dr Middleton giving evidence first, then Stephen Robb. And I should say that because each of those witnesses have prepared fairly extensive rebuttal precognitions in a break with tradition so far, and in order to focus on the issues and save a bit of time, I don't intend to ask those witnesses to read their full precognitions. I'll ask them to refer to their rebuttal precognitions. And for that reason, it would be useful if all parties had a read through the main precognitions before the witnesses come to give evidence.
That's fine. Thanks, Mr Mackay. Happy with that, Mr Steele? Anything else?
I'm perfectly happy, sir. I'll only be working from the main reports anyway, as long as you're happy.
Okay.
So I'm
any
able
other
to
issues?
report news on
Mr.
Dr.
McIntyre.
Batas. So, if I remember correctly, where we left matters was the final Friday. Dr. Batas and Dr. Conlon were down to be here on the same day. I've spoken to Mr. Innes overnight, and he continues to hope that Mr. Conlon will call first, although he's attempting to see if he might call the day before, but there's no answer on that. In respect to Dr. Batas, he's able to go second because he's not leaving Edinburgh until the Saturday morning. So I think it would then be Conlon followed by Batas on that day.
Okay, but both still okay for that day, the Friday of the 5th week. Perfect. Anything else, anyone? Okay, in that case, we'll close for the week. Have a good weekend, everyone, and we'll adjourn or we'll resume at 10 o'clock on Monday morning. Thanks.